if they're obligated to do a supplemental environmental impact statement, they will presumably go through a process which I think you will find will expand well beyond what we've been talking about here, because there are many other issues that they have to deal with, like moving from their normal sort of construction to unit construction, whatever they call it. You'll probably see a very significant supplemental EIS would be my guess. And we're advised that they've already...
Well, I think it's a little different. Scope talks about what they look like in the EIS, and it's just not required under law. It's optional. And so, but effectively, you're right, we were talking that they didn't look at the right scope, the right issues. But as Al said, I mean, if they don't do scoping, we'll get comments in anyway, and they have to respond to them, which is, we never had a chance to comment on the 2010 supplemental analysis. Technical analysis. So, there wasn't anything to put in the expert reports that, Prospect Heights put in, and there was no opportunity, no requirement for them to respond to it. And they'll have to do that if they do an SEIS.
One more question. Can you guys distinguish, and I know you did some of the legal papers, they were talking about the Wilder case, and stuff. Our city's contention is that the Wilder case essentially precludes this. So can you boil down your analysis of the Wilder case?
I think that it's different in a number of respects. The most important is that people weren't arguing about the length of the construction as the impact. They were arguing about what it would be like at the end of construction. We have a much stronger argument, which is the elongation of construction itself has very significant impacts, which we actually think are more serious than whatever happens at the end of it. But those are the ones that really have to be taken into account. So it's a different focus.
Wilder was about
Times Square,
but the ultimate configuration of the project?
Well, both. It was about both the ultimate configuration, because they changed the nature of the merchandise mart, and that supposedly raised changes. But a lot of the change in the timing was that I think 5 or 6 years had passed through the original EIS to the change in the project, and the petitioners in that case were arguing that amount of time in and of itself raised changed circumstances that required an analysis, and the court said in and of itself that delay in the time frame doesn't change things. As Al said, this is apples and oranges, because we're talking about a 25 plus year time frame of construction, which was never looked at. I mean, they assumed essentially a 10-year period that would provide all the benefits of the project, and that's not the reality.
Appropriated the money, like $4 million, to do an EIS, which we assume means they're planning to do more than just this.
They've actually said they're conducting a supplemental EIS.
No.
That's what they told me.
Well, they haven't done anything to really start the process. There's certainly no scoping that's been being done.
Right, but what would be the difference between conducting the work of an SEIS that is the work without the formal process?
Well, I think there'll have to be a formal process, so I don't really know what the question is going to be. If they prepare an SEIS, either because this court orders it or because they decide to do it on their own, then they will have to send it out. They'll probably have to have a scoping process in which people identify the issues that they think ought to be considered, and then they'll have to prepare a draft environmental impact statement. And then they'll have to circulate that and have a hearing on it, and then they will get a final EIS. And it's an opportunity, I think, for people to really come and talk about things like Jeff talked about at the end of his argument, that why should Forest City continue to be the sole contractor builder in this? It's quite possible that other developers could move the thing along more quickly, might be willing to do it with less intense development. There are lots of options that might be possible.
So if they do an SEIS and ESDC comes up with a different finding, as they're legally right to, for instance, they decide we're going to change what phase 2 looks like, and we're going to divide it up and have different people come in, and maybe we'll change the scale of the buildings, right? Forest City Ratner, in our opinion, can't rely on that development agreement and say you're already contractually obligated to do this with us, because that agreement was premised upon an illegal analysis that predated it, and we had filed a lawsuit on it. They were on notice. I mean, will there be a fight about that and an argument as to whether they're constrained? I'm sure there will be, but we'll worry about that later. But you have to, where we are now, being successful, is the court has said phase 1 can go forward, phase 2 needs another analysis. There's no then presumption of validity, of legality of the phase 2 contract. And that's where it begins. It is a state project. The state decided they wanted to undertake this approval of Vanderbilt Yards. If Forest City Ratner is not the right company to do this, somebody else should be developing it. There should be alternate development plans that the community's been working on for years.
Just trying to get a sense of whether there are time pressures related to getting the SEIS.
There are under their current contract, if they're held to their current contract, there are no time pressures at all, and that's why the lower court said there's no stay necessary, go forth and do the SEIS. Their time pressures, which they're having trouble meeting, is their deadlines under phase 1.
Right.
Are they going to get all the infrastructure in place before the arena opens in September? Doesn't look like it, or they're only doing it by increasing the impacts on people. Are they going to get the buildings built that they have to by the various dates?